So I'm so pleased to be joined today by Katie Fallow, who is a senior staff attorney at the Knight First Amendment Institute at Columbia University in New York. She has been in private practice as an attorney before going into this very interesting nonprofit sector work where they do public interest litigation, advancing First Amendment rights. And I want to invite her to talk a little bit more about that. We're going to have a conversation today about First Amendment rights as they apply to online speech and the internet, and in particular, some of the recent developments in the law about the First Amendment and the right of access to speech on social media platforms and how the government cannot prevent people from reading government material that is posted to the internet just because they don't like people's viewpoints. I guess to start out, Katie, just tell us a little bit about how you came to be doing this work and what the portfolio of the Knight Institute looks like.
Yeah, so thanks for inviting me to talk with you today. And as you mentioned, I was in private practice at a law firm in Washington, D.C. for 15 years, the law firm Jenner and Block. And during that time, I developed a practice specializing in First Amendment and media law. In particular, I represented the video game industry in a series of cases over about 10 years, where the industry was challenging state laws that would have restricted the sale of violent video games to minors. And that case eventually, or the cases eventually went up to the Supreme Court and were decided in the case of Brown versus Entertainment Merchants Association, and where the court held that minors have a full First Amendment right to play video games or access books or movies that depict violence, images of violence. And this ties in with what I am doing currently at the Knight Institute, because particularly it may seem now like, oh, video games are very much a mainstream part of our culture, but in the early 2000s and late 90s, there was this big push to regulate them. And there was a sense that video games were somehow outside the First Amendment. They were a new form of expression. They were something that maybe judges weren't familiar with. And so part of it was applying pre-existing First Amendment law to what is considered a novel form of either artistic expression or communication. So I did that work for a long time at Jenner and Block. And then after I left, I practiced in the government for a little bit at the Federal Trade Commission. And eventually my family moved from DC to New York City. And it was just fortuitous timing because the Knight Institute had just been established at Columbia University. And I had this experience. And so it just was a really great fit. And I made the transition, as you mentioned, from private practice to a nonprofit. The Knight Institute was set up by the Knight Foundation and Columbia to address, sort of writ large, First Amendment in the digital age. And sort of our broad mission is to strengthen and protect free speech rights in the digital age. So once again, to look at the ways in which either new forms of communication, social media, obviously the internet, online communications, and to the extent that they raise new or their own speech problems, and how do you address that?
Yeah. So students in this course are going to be familiar with cases like ACLU Reno, where the Supreme Court has refused invitations to diminish the First Amendment protection of online speech, even though there's kind of this widespread perception among a lot of policymakers that online speech is worse than speech in other forms and that should be subject to more regulation because of its dangerousness. And I think one of the things that, one of the points that you've made as a litigator representing the video game industry is that we've been here before, right? Every time a new generation of media comes along, there is an existential panic about how harmful and dangerous it is, and there are attempts to regulate it, and under the First Amendment, it invariably ends up going nowhere.
Exactly. And, this is not to diminish that there can be real world or real, tangible harms associated with speech, or that speech can have a big impact. but I agree that it's important to be cautious when sort of the latest iteration of these speech harms comes around. There is tendency to have panic and think, let's regulate it all, and that's what they did in the law that was struck down on ACLU versus Reno, because there was a real concern about minors accessing sexually explicit material on the internet. Kind of at the beginning of the life of the internet, and currently we see a lot of talk about regulating speech, either particularly focused on social media platforms or in the context of this federal law, which is actually left over from the ACLU versus Reno case, Section 230, which said that that websites can't be liable for the content of users that is posted on their website. So, certainly in the video games cases, we saw it was remarkable, an echo of the same arguments were made about video games, that they were so harmful. I mean, there was a whole body of social science literature purporting to show that playing violent video games would cause children to become violent. And it was a sense that it was going to create this sort of new sociopathic or asocial generation. And when I was working on those cases, we looked at the history of comic books, and people said the exact same thing about comic books. So this is not to say that there aren't things that you can be concerned about, or as a parent want to talk to your kids about new forms of entertainment. But I do agree that we really need to caution against having the solution to these supposed harms or alleged harms be widespread regulation, because throughout our history you can see this instinct by governments to try to restrict speech, but it often is just too broad and too vague, and carries too much risk of being used by government officials to suppress unpopular viewpoints.
And you just said the two magic First Amendment words, vagueness and overbreadth, right? Which is something we emphasize throughout the course, that fatal to any kind of a speech-directed regulation is either the regulation is too vague, doesn't give people notice of what's being banned, or it's overbroad. That was the common denominator in a couple of cases that we've talked about just now, the ACLU Reno case and also the Brown Entertainment Merchants cases, in an attempt to get at some subset of harm-causing speech. The government adopts a wide-ranging regulation that puts all of it off limits, and invariably the courts say, no can do.
Exactly. And also, I think what the courts often do when you have a law restricting speech, particularly based on content, which would trigger strict scrutiny, is to look at whether the law is tailored to the government's purported interests. And often, even if the government has a legitimate or worthy interest, these broad restrictions on speech don't actually serve the interest in a appropriately tailored way. So you're often not really accomplishing anything. And then the downside is you're restricting all this speech. We have a case right now at the Knight Institute where it's complicated for a lot of other reasons, but it's challenging a federal law that requires any person that's applying for a visa to come into the United States to provide their social media handles for the past 5 years. And some of the challenges to that case is because the people who are applying for visas are not US citizens necessarily, I mean, by definition, but we represent some documentary film organizations that often engage in all this cultural exchange with documentary filmmakers who are seeking to come into the United States. They have to provide these social media handles that providing them can compromise any anonymity they may have. And there often are political outsiders or dissidents who could be at risk for being persecuted in their country. And so the result of it is they may refrain from engaging in that kind of speech on social media if they know the government is going to be listening, or they're not going to come to the United States, and then the documentary filmmakers lose out on that exchange. So I think that's an example of a law where it's just so broad, it's basically asking for 19 million people every year to give their social media handles. And I don't think it's serving the purpose that they that the government is purporting to serve, which is, enforcing the immigration laws and guarding national security.
Yeah, that's such a perfect example of a lack of narrow tailoring in the drafting of a perhaps well-intended statute that ends up having all sorts of undesirable spillover effects and a chilling effect on the ability to engage in speech about issues of social and political concern. It's also a great example of what I call like social media exceptionalism, that there is this sense among regulators that we can regulate social media in a way that we would never have regulated any other speech, right? I mean, imagine had Congress or had the immigration authorities said, we want copies of any letter you've ever written to a newspaper or any letter you've ever written to an elected official as a prerequisite to being able to enter the country, people would recognize that immediately as a gigantic First Amendment problem. In fact, nobody would contemplate that kind of regulation, right? But because it's social media, there's the sense that somehow we get to regulate that in a way we would never think about regulating other forms of speech.
Yes, exactly. Yeah. And you see a lot of the debate about social media and whether it should be regulated and whether the Congress should amend Section 230 to place greater restrictions or obligations on social media companies. Sometimes in that discussion, you see people saying, well, and then you could sue people for harmful speech, but that always leaves out for what, I mean, because you don't normally just get to sue someone because you don't like their speech. It has to fall within certain, acceptable, like actual defamation type of thing.
Yeah. Well, so I want to make sure that we save time to talk about Katie's, one of her claims to fame. She's kind of a First Amendment celebrity because she's the attorney that took the case to court against Donald Trump over the blocking of citizens from being able to access his Twitter account. I want to make sure we talk about that. But to set the stage for that, we should talk a little bit about this idea of the public forum, this idea that a piece of government property can be a forum for expression, and then specifically maybe talk a little bit about how in the world a virtual piece of property like a social media account could be analogized to a park or the podium at a city council meeting or some other physical piece of property that we're familiar with.
Yeah, so I mean, this did come about basically with the president's Twitter account, meaning that the case came about at the Knight Institute. The Knight Institute had just started, as I mentioned, in 2016. So I started basically at early 2017, and we were ramping up and kind of considering ourselves a First Amendment startup and, looking for litigation that would be within this broad mission of speech in a digital age. And we had heard reports that the president had dropped, well, first of all, everybody was familiar with his Twitter account, and it was the same Twitter account, the @RealDonaldTrump Trump account, that he used as a private individual and then as as a campaign outlet during the 2016 campaign. And at the time, it seems almost quaint now, but there was, question of, well, is the president going to continue to use his personal account once he's president, or is he going to switch to the more, official @POTUS account? But he continued to use his @RealDonaldTrump Trump account, presumably because that's where he had a ton of followers. And I think when he started, maybe at 20 million, he now has upwards of 80 million followers. And so we could see in the first half of 2017 that he was using his personal account, but to do a lot of official things. And then we started hearing reports that he was blocking people from his Twitter account. And to some extent, we saw people posting on Twitter, oh, I was blocked from the president's Twitter account. And some people almost saw it as like a badge of honor, blocked by Twitter. There was a Twitter group, blocked by Trump. And so we started looking into it as whether is this legal? Can you bring a First Amendment claim? And so that's when we looked to the public forum doctrine, because as you mentioned, for decades, the Supreme Court has held that a space that is owned by the government or controlled by the government, when the government opens that space up to the public to engage in speech or expressive activities within that space, it is considered a public forum. And there are different kinds of public forums. Sort of the classic traditional public forum are sidewalks, and parks. And those are considered as sort of have been public forums for time immemorial. And, there's harkens back to Hyde Park in London before even our founding. But the idea of someone getting up in a soapbox in a public park, and that it's so critical to the First Amendment that the government not be allowed to censor or, punish anyone for speaking their mind in that forum, because you want people to be able to say what they can, and to let all these different ideas percolate and to have people listen to them. So then there are other kinds of forums. That's traditional forum. Traditional forum is always just a park or sidewalk. So a non-traditional public forum, but is considered a designated public forum, is when the government, for instance, if the government has in City Hall and they have a big auditorium and they open it up for a city council meeting, and they allow members of the public to come in and listen to the city councilors, but they also give the public an opportunity to speak in that meeting. And so that would be considered a designated public forum, meaning that the government has decided to open up this space to allow people to speak in it. And the courts have held that when you have a designated public forum, the government cannot tell one person they can't speak in that forum because of their viewpoint or because of the content of their speech. So that's kind of the existing law. And then, as you said, the question was, well, can that existing framework be applied to the president's Twitter account? And there are several different steps, but as we started thinking about it, it made sense. Because first of all, the Supreme Court, even before the internet, held that the public forum applies not just to a physical room, but to a metaphysical space, in the words of Justice Kennedy, meaning, and that was in a case where it involved funding for student newspapers. And the court held, it's Rosenberger case, and the court held when a state university is providing funding for student organizations, it has created a public forum in that funding stream, and it cannot discriminate among viewpoints, in that case, against a religious viewpoint in that funding stream. So because it applied to a metaphysical space, then the fact that a Twitter account is not a physical space was not a barrier to our First Amendment claim. And so what we made the argument is that the president was using his account like a town hall, like a open city council meeting, and where he stands at the virtual podium at the front of his Twitter account and he speaks like a city councilor would speak. And then all of his followers, any member of the public, can reply directly to him by pressing the reply button on Twitter. And because he uses it for official purposes, the big argument that the government made when we filed our case was, oh, this is his purely private account. This is not a government account. Maybe the @POTUS account is a government public forum, maybe, but not his personal account. So then when we brought our case, what we showed is that he just kept on using the @RealDonaldTrump account to engage in all sorts of official acts. To announce foreign policy, to announce major policy initiatives like a ban on transgender individuals serving in the military, to announce appointments, cabinet appointments, a whole host of, really official acts that he was carrying out via Twitter.
He's even fired a couple of people on Twitter, I think.
Oh, yes. I think many people he's fired on Twitter. So what we argued, and the courts agreed with us, is that even though it was ostensibly a personal account, he was using it like an official account. And he, in fact, had his staff, his head of social media, Dan Scavino, help him run this account by posting tweets, by vetting tweets. And so the courts held, because as the reason why this was so important is the First Amendment only applies to actions. I mean, the requirements of the First Amendment only apply to actions by the government. So while the DOJ was arguing, oh, these are just his purely personal views that he's expressing on his Twitter account, the courts held, no, he's engaging in, quote, state action when he operates this account. And then once they've satisfied that test, the courts also held that this was a public forum, a designated public forum, because his account, even though he's speaking, when he speaks, oh, my cat's trying to get into the frame, there you go. He's too interested in First Amendment law. When he's speaking, that might be government speech, but when the ability of everybody to reply to him, that's not government speech. That's the public speaking in a public forum. And in our case, we represented 7 individuals who had criticized the president. These were just kind of ordinary Americans across the country who criticized him or his policies when they replied to one of his tweets. And, at the beginning, a lot of people thought, oh, maybe these were really vulgar or threatening replies that they made, but they weren't. They were sort of either mocking him or saying, oh, the Russians won the presidency for you, but nothing really particularly outrageous, even though outrageous speech is protected by the First Amendment, but this wasn't even outrageous. It was pure core political speech. And it was one of the interesting things in our litigation of our case is that the government stipulated to a bunch of facts that the court then decided the case based on that stipulation. And one of the stipulations was that the president personally blocked these people, and they basically conceded that he did it based on viewpoint. And that is the most verboten thing in First Amendment law. So once you have viewpoint discrimination, it's very hard for the government to justify that kind of action.
Right. So just to put an underscore around some of the points that you made, viewpoint discrimination means that had these very same people interacted with that account and said, "Attaboy, Trump, way to go, MAGA," they would have been welcome to stay on that virtual piece of property and continue interacting with it and continue receiving information. But because they expressed unfavorable viewpoints, that was the decisive factor. And once you establish that he's using governmental power to hit the kill switch, either he's doing it in his presidential capacity or some government employee, which was a helpful fact, is doing it for him on the government dime, hitting the kill switch and deactivating your access to the account, then you've got all the makings of a First Amendment case. You've got state action, you've got viewpoint-based discrimination, and you've got a willing recipient of information, a willing speaker who wanted to be able to engage on this piece of what we've now established to be at least government-controlled property, even though it exists out in the ether. So really interesting and creative use of some old First Amendment doctrine.
Yeah, thank you. I just want to make one point is also, I think it's important to emphasize that this is a nonpartisan approach or argument, because it doesn't apply, Trump is the most high profile defendant in one of these cases, but now, and we filed our case in 2017. And since then, there have been, upwards of a dozen other cases arguing that government officials, kind of at all level of government, and Democrats and Republicans who use social media in furtherance of their official duties as a public official cannot, consistent with the First Amendment, block people from those accounts based on viewpoint. So the day that the Second Circuit decided our case and the Trump case, someone sued Alexandria Ocasio-Cortez for blocking him from her Twitter account. And she eventually settled that case and, essentially acknowledged that she was using her account as a public forum and she can't block people based on viewpoint. So I think it's, Trump's the most high profile defendant, but it's an important principle to establish as more and more public officials use social media as the primary way to talk to and hear from their constituents.
Yeah, you actually anticipated where I was going perfectly, which was, I think there are probably some people who will look at the Trump case and say, there's hardly a problem with gaining access to Trump tweets, right? If you want to read Trump tweets, there's any number of places that you can go to do that. And so the idea that the president could theoretically click the block switch and keep you from interacting with his account would not in any way cut off your ability to see what he's been tweeting, by following news sources. I mean, doing lots of other things. But there is a larger principle at stake here, right? Which is both that it applies to elected officials at all levels, and that it applies for any other virtual property that government chooses to use in the future.
Yeah, absolutely. And it's not an outright ban, obvious, like for the reason you said, you can speak on Twitter and not be replying to Trump, but it's not, even if you're blocked, you're still able to speak on your own account. And as you said, you could read about his tweets in the newspaper. So it's not like a huge burden, or you're being, censored under penalty of criminal, punishment. On the other hand, it is a burden on your speech. And the only reason that burden was being placed on our plaintiff's speech was just because the president didn't like their viewpoints. And that's just not even a legitimate government interest. So it cannot justify that level of a burden. But also, one of the amicus briefs in our case pointed out that actually, a lot of local governments use Twitter as a way to provide emergency information to their community. And if you've been blocked because the mayor doesn't like you, but then the mayor's tweeting out important information about a hurricane or an emergency, and often people are checking Twitter in these emergency situations, and you can't get that information readily, and that's a real effect.
Yeah, that's a great point. And in fact, at a public university, the way that we get notifications of things like a crime in progress, active shooter, take cover kinds of things is on Twitter. And so increasingly that's become the medium of choice for government agencies to try to get information out to a lot of people. And that seems like that's only going to increase in the future, whether it's Twitter or whether it's whatever takes the place of Twitter a decade from now.
Right. Exactly.
Yeah. So just by way of wrap up, I kind of want to give you an open-ended invitation to either talk about any other issues in this area of the interaction between the First Amendment and social media that are intriguing to you, that you can envision yourself working on, or otherwise just talk about what's on your plate at the Knight Institute. I know, for instance, you have a really interesting case about the ability of people who've worked in the intelligence community to be able to write books that draw on their expertise that they've gained as government employees without having to be censored by the intelligence agencies before they can publish. So that's one of the things that's on the burners at the Institute. But I guess just wrap us up by talking about kind of where you see your work going.
Yeah, well, one thing I will say, and again, and I've somewhat building on what I've already mentioned, but that it's been extremely gratifying to be involved in these social media blocking cases because, as I mentioned, first of all, to be part of developing a body of law that's new. It's drawing on these existing public forum state action doctrines, but applying them to this new phenomenon, and both applying it to the most powerful official in the world, President Trump, but also applying it to public officials, in local government, in members of Congress, et cetera, and also seeing how then that can be used as a building block to apply these First Amendment doctrines to, as you were saying, as yet previously unthought of ways that the government is using different technologies. So, for instance, this past summer, we became aware that the Army had been, and the Navy and other branches of the military had been using Twitch, which was something I was completely unfamiliar with, even though I have this background with video game, with the video game industry. But Twitch is this video game streaming service, and the Army, which has always used video games as a recruiting tool, was using a Twitch channel where members of the Army or the Navy would play video games like Call of Duty and other games, and members of the public who are watching this streaming could chat along during the gameplay. And some people started saying, and the people who were in the military who were playing it were saying things like, this is the kind of life you have in the military, like it's great. And someone said, oh, what about if you are engaging in war crimes or something to that effect, basically being critical of the military and saying, oh, this is the other side potentially of being involved in the military. And they blocked him. And so, this was a totally new kind of platform for us, or at least to me, I guess not to everybody else. But, and so we represented someone and wrote to the Army and Navy and said, we believe this is a public forum for a lot of the same reasons developed in the Trump case and other cases. And blocking people from this forum based on their viewpoint violates the First Amendment. And they did unblock our client. And then issued use policies governing the chats on Twitch when they were streaming games. And we think ultimately that is the right way to go, is that we don't want to have file lawsuits all the time, but that as people become more comfortable with this doctrine and more knowledgeable about it, that they should adopt use policies that make it clear to the public what is, you can't engage in true threats, fine, but everything else, you're allowed to do, and giving notice to people about what you can and cannot do. I just think that's the best way to develop as people more and more, as government more and more uses these kind of interactive platforms as a way to interact with the public. You also mentioned, yes, we have what we call the PPR case, pre-publication review. And I think that's a really, interesting area of, where you have former government officials that have to have anything they write reviewed by the government. And because there are all these different frameworks that apply depending on where you worked in the government, it's all for the purpose of making sure that people aren't publishing classified materials. But again, coming back to overbreadth, it imposes all these obstacles and hoops on people, and can be used particularly for unpopular speech, a book that's critical of the government, to basically delay, the timely publication of a former government employee about important information that we as the public want to know. In that case is, we lost the claim in the district court, and it's now on appeal to the Fourth Circuit. I think that's also an area where possible legislation would be another way to get in, and not just filing lawsuits, but actually you can have a legislative effort to try to address the issues.
And just to really hammer this point, because I think it's so important to understanding the First Amendment and the public forum doctrine. A lot of people who've been trained in and who've studied advertising or public relations are probably listening to this and thinking, well, why should the government have to give a platform to people who hate the government? Why should the government have to entertain people who want to say the president sucks? If I go into the Macy's department store and I've got a protest sign that says don't shop at Macy's, they can kick me out, right? They can protect the brand by saying you're not welcome to voice your opposing views on our property. Take it somewhere else. So why doesn't the government get to do that?
Well, I think that's because a very central part of the First Amendment is it says that the government may not censor speech based on, and then as interpreted by the Supreme Court, based on things like your viewpoint. And that sort of baked into the First Amendment is the idea of the government should not be able to censor speech that it just because it doesn't like it or because it's critical of the government. Because one thing that we consider, I think sort of sacred to our First Amendment and civic discourse is the ability to criticize the government. And, I think there is a concern. So certainly if you're Macy's, yes, you can block people from your social media platform. I can block people from my social media account because I'm a private individual. When President Trump is no longer president, he can go back to blocking anyone he wants from his @RealDonaldTrump account. But there's also been a number of cases that the Supreme Court has held that when you're a public official, you assume a duty to kind of either be thick-skinned or, you could, and if you have a Twitter account, you could mute it. You don't have, if you're really just an individual public official and you don't want to see someone criticize you, you could mute them. That would be better than blocking someone because you don't have to see it, but you're not preventing that person from speaking or speaking to other members of the public.
Well, thank you so much for sharing the benefit of some of the backstory that went into the Trump Twitter case and your other interesting work at Knight First Amendment Institute. So thanks to Katie Fallow for sharing your expertise and for the really interesting work that you're doing as a First Amendment litigator.
Well, thank you. My pleasure. Thanks for inviting me.